thousands of stars you see when you look up at the night sky, every one of them living in between two collapses. An initial collapse of a dark stellar gas cloud that formed the star, and a final collapse of the star on the way to ultimate fate.
Okay, guys. Hope you guys had a good day. Hey, I had a lot of financial reports and stuff to do today because the end of the year is coming up, and I'm still trying to get done with third quarter stuff, but I wanted to go ahead and share this information. I know you've heard people say that Judge Gloria Navarro was handpicked by Harry Reid, and I wanted to let you know that those that were subscribed to him got his farewell message before he left office, okay? I was one of those subscribers, not because I was a supporter, but I just wanted to keep up on what he's doing. I often do that with Democrats to find out where their focus is and stuff like that. Okay, so I wanted to show you a part down here. Okay, here we go. I've got it highlighted. And this is where he addresses the judiciary. He says, you know, I talked earlier this morning, I'm a lawyer, and I'm proud of the fact I was a trial lawyer. I hear senators talk all the time about the judicial selection committees they have picked, who they're going to have on a federal bench, and I'm glad they do that, because I also have a judiciary selection committee. You know who's on that committee? Me. No one else is on it. I've selected all my judges. Now, he refers to them as my judges. They belong to him, okay? I'm the committee, and I'm very happy with what I've been able to do. One of the things I did in the House, I named a federal building in Las Vegas after the very famous family of lawyers. 2 federal judges, a district attorney, a state court judge, a wonderful family called the Foley family. So I go back for the 10th anniversary, and I look up there and nothing but white men. I thought to myself, gee, I hope someone can change that. And as fortune would have it, the Lord George decided to take senior status, and I had a chance to do something about that. And I have done. I have sent names to the president. I have selected far more judges myself and the entire history of the state of Nevada and other senators. So what I did with the first one, well, I wanted to get a woman. We don't have a black one on the court either. Why not get a black and a woman? And that's what I did. Oh, I was criticized. Oh, she didn't have enough experience. You could have found somebody better. She was a dynamo. People loved this woman. She was so good that she's now on the 9th Circuit, and she quickly went there. Make a long story short, she's been part of the talk about who could go on the Supreme Court. This is a wonderful woman named Johnny Rawlson. I put Roger Hunt, a great trial lawyer, on there. Kent Dawson, one of my predecessors, city attorney. David Hagan, a wonderful trial lawyer out of Reno. I put him on the bench. Brian Sandoval, I selected as a federal judge, and he was a good federal judge. Things were going great until he ran against my son for governor, and I wish he hadn't, because my son would now be governor. But he's my friend, and we have family, accepted that. But he was a Hispanic, first Hispanic on the bench. I appointed another Hispanic, Gloria Navarro, parents born in Cuba. She's a woman. Now she's the chief judge. Okay, so that's where we got it. He handpicked her. He is his judicial committee. Okay, there's no one else on that committee but him. So he handpicked her. And here's a picture of them right there together. And there's something that I wanted to bring to you guys' attention, okay? Because that judge is in quite the little predicament, okay? This article came out by Slate.com. It says, For shame, the criminal justice system encourages prosecutors to get guilty verdicts by any means necessary, and to stand by even the most questionable convictions. Can one crusading court stop the lying and cheating? And this was by Laura Bazelon. Okay, and this is, the court she's talking about is the Ninth Circuit Court of Appeals, okay? In 1995, John Adair and John Mix, a gay couple lived in Riverside County, California, were murdered in their home. Both men were shot in the face. Mix died immediately, but Adair lived long enough to call 911 and respond when the police asked him who the killer was something that sounded like Baca. Johnny Stephen Baca, the couple's live-in housekeeper, was arrested and charged a few days later with first-degree murder. His trial took place in Riverside County Superior Court in the city of Indio, about 130 miles east of L.A. The prosecution's theory was that Baca killed Adair and Mix in a murder-for-hire plot masterminded by Adair's adopted son, Tom. But the evidence of a conspiracy was thin. Baca didn't confess, and no forensic evidence linked him to the murder weapon, which had been recovered at the crime scene near Mix's body. Tom Adair was never charged with the murders and did not testify against Baca. After John Adair's death, Tom inherited nearly $500,000 from his father's estate, but there was no evidence that Baca knew about the inheritance or that he received any of Tom's money. Instead, the trial prosecutor, Deputy District Attorney Paul Vingard, relied on the testimony of Daniel Melendez, a jailhouse informant who was facing his own murder charges for killing a man named Mario Gomez with the help of an accomplice. Melendez told the jury that Baca had confessed to killing Mix and Adair at Tom's behest. Asked directly by defense counsel if he was receiving any favors from Vingard's office in exchange for his testimony, Melendez said no. Vingard then called his colleague, Deputy District Attorney Robert Spira, who was in charge of prosecuting Melendez. Under oath, Spira told the jury that Melendez had agreed to plead guilty to voluntary manslaughter in exchange for Spira's recommending a 14-year prison sentence. Spira was empathetic, however, that this deal was based solely on Melendez's decision to inform on his co-defendants in the Gomez murder. Melendez's testimony against Baca, Spira told the jury, had no bearing on the state's leniency, which was substantial. Melendez's initial murder charges carried the possibility of life sentence. Several months before Baca's trial, Spira made the same representation to Melendez's sentencing judge, H. Dennis Myers. The judge was incredulous that Melendez would testify against Baca simply out of the goodness of his heart, thinking in Myers' words, well, heck, I'll go up and testify in another murder case, and I don't expect anything from them. Melendez's attorney chimed in, telling Myers that his client had in fact been led to believe there would be a reward at the end of the rainbow. Given Melendez's cooperativeness in the Baca case, Myers said he was inclined to give him less than 14-year sentence the state had already promised. Myers lacked the legal authority to do so, however, if prosecution opposed him. He then asked Spira's colleagues, Kevin Rudy, who was also present, I'll just cut to the quick. What is the people's position if the court further went down from 14? Further downward sentence? Rudy replied. We would not appeal the court's decision. Melendez ultimately received a 10-year sentence for his cooperation in both cases. Spira was in the courtroom representing the state of California when the court pronounced Melendez's final sentencing. Testifying at Baca's trial, however, he concealed the fact that Judge Myers had explicitly taken Melendez's testimony against Baca into account in his sentencing and at times affirmatively lied about it, insisting that the only reason Melendez got the extra sentence reduction was due to a change in sentencing laws that happened to benefit him. Baca was convicted of first-degree murder and sentenced to serve 70 years to life in prison. After unearthing the transcript showing what actually transpired at Melendez's sentencing hearing, Baca's lawyer filed an appeal demanding that his conviction be overturned due to prosecutorial misconduct and false testimony. The California Court of Appeals agreed the state's conduct was egregious. The justice characterized Spera's testimony as sheer fantasy and took a dim view of the district attorney's elaborate verbal tap dance to defend it by arguing that Melendez received no extra favors from the state in exchange for testifying against Baca because the windfall technically came from Judge Myers. This kind of hypothetical parsing does not dispel the highly misleading nature of the testimony, which sent a single unwavering, blatantly false message to the jury, that the informant sought nothing and got nothing for testifying against the defendant. And yet, the state appellate judge declined to reverse Baca's conviction. Although Melendez and Spera had perjured themselves, the judge found that their false testimony did not prejudice the outcome of the trial. While the question was close, they concluded in the end, we do not see a probability of a different outcome. And so this is a rather long article, but what it basically says is that the Ninth Circuit Court is the most liberal of courts, known for its repeated clashes with the Supreme Court, particularly in cases like Baca's, where a prisoner is asking a federal court to intervene in a state court case. Okay? Here's the issue. The Ninth Circuit Court, if you're found guilty of something, even if the prosecutor lied and misled the jury, the Ninth Circuit Court is reluctant, almost insistent on not overturning a ruling at the state level if the person's been convicted, okay? But here's the issue that Gloria Navarro finds herself in. These guys have not been convicted, okay? The Bundys have not been convicted yet, guys. So, is she going to shoot for a conviction in hopes to get one so that all this prosecutorial misconduct, this malicious prosecution, all this kind of stuff, it doesn't matter if they get a conviction? Or will she dismiss the charges with prejudice and walk away? Well, let me tell you, if she dismisses the charges, here's what could happen. A criminal prosecution that is pursued maliciously and without probable cause can create a civil case of action. To state a claim for malicious prosecution, a plaintiff must show 1. Prosecution for a criminal offense, 2. Instigated without probable cause, 3. With malice, and 4. Under a valid warrant, accusation, or summons, which they got from the grand jury. Remember that, guys? And 5, which has terminated favorably to the plaintiff. Okay, so if she dismissed the charges, that is favorable to Cliven Bundy and them, and it would meet the 5th element of malicious prosecution. 6, has damaged the plaintiff, which we know, guys, 2 years of their life have been taken away. Malice may be inferred from a lacking of probable cause. So here's the deal, guys. To dismiss with prejudice would set it up for malicious prosecution. All 5 elements will have been fulfilled. Well, I'll get into the details of it here going down further. A malicious prosecution may also violate the 4th Amendment and thus create a claim under 42 U.S.C. 1983. To establish malicious prosecution claim under that, the plaintiff must prove a violation of his 4th Amendment right to be free from unreasonable seizures, in addition to elements of Georgia's common law. Or, you can mark that out because we're not talking about Georgia here. Of malicious prosecution. Under federal law, okay, so it goes down through here again. So to dismiss these charges would set up a case for malicious prosecution. Under 42 U.S.C. 1983, all 5 elements will have been met. If she doesn't dismiss it and decides to take all this to trial, hoping to get a guilty verdict, what'll happen is the Ninth Circuit Court is not going to overturn that ruling, even though it's been proven that the prosecution engaged in misconduct, even broke the law. Okay? So they either have to be found innocent, or she has to drop the charges against them with prejudice. Okay? And here's the next issue I want to talk about. The charges, the criminal charges that Steve Myrie and his little sidekick there, Ahmed, could possibly be facing. But I do know for sure that Steve Myrie could face these charges if, there was an investigation, whatever. I don't think that'll happen, but I just wanted to show you guys some of the federal criminal laws. Although it now covers more than court proceedings, the definition of perjury has not changed a great deal otherwise since the framing of the Constitution. Blackstone describes it as a crime committed when a lawful oath is administered in some judicial proceeding to a person who swears willfully, absolutely, and falsely in a matter material to the issue or point in question. There are 3 general federal perjury laws. One is 18 U.S.C. 1621, outlaws presenting material false statements under oath in a federal official proceeding. The second, 18 U.S.C. 1623, which bars presenting material false statements under oath before or auxiliary to federal court or a grand jury proceeding. Third is 18 U.S.C. 1622, which is subordinating perjury, prohibits inducing or procuring another to commit perjury in violation of either Section 1621 or 1623. Okay, so when Dan Love testified at the grand jury, we know the man had to lie in order to for the grand jury to agree with them, and they levy those charges against these men. Steve Myrie had to have known. He was out there at Bundy Ranch. He saw the conditions. He was part of the plan to take down Cliven Bundy, which is covered even in more federal laws, conspiracy to commit perjury or conspiracy to subordinate perjury. Okay? So every presenting material false statements under oath in a federal official proceeding, if he, in his opening statement, he just outright lied. In court, he's lied repeatedly in this third trial, but most important is he subordinated perjury in a grand jury proceeding. When Dan Love testified, he had to have known Dan Love was going to lie, and we know that Dan Love did lie, okay? But you don't have to prove, to secure convictions for subordinating a perjury, the perjury sought must actually have been committed. U.S. versus Hairston. Okay, the underlying perjury must be proved under the standards required. Now let's go down here. Conspiracy to suborn perjury may be prosecuted irrespective of whether perjury had been committed or not. The two-witness rule doesn't apply in the conspiracy prosecution. Solicitation of perjured testimony may also be prosecuted as obstruction of justice, irrespective of whether the perjured testimony took place or not. U.S. versus Silverman. Because the crime of subordinating perjury is distinct from that of perjury, the suborner and perjurer are not accomplices. However, a person who causes a false document to be introduced through an innocent witness can be held liable as a principal under 18 U.S.C. 2B, U.S. versus Walsher. Okay, the attorney's ethical obligation when confronted by a client who wishes to testify falsely are discussed at length in Nix versus Whiteside, 475 U.S. 175 in 1986. Says see also Rules 1-102 and Code of Professional Conduct and yada yada yada. Obstruction of justice is the impediment of government activities So where he interfered with the investigation, those that shredded the documents or that were witness to the document shredding, when he interfered with that investigation and made sure that none of those that participated in the shredding or were witnesses of the shredding were interviewed, he interfered. He impeded government activities. Also, not turning over Dave Bundy's iPad, knowing that he had a ethical obligation to do so. I mean, there's a whole host of things this guy did, which it says right here. There are a whole host of federal criminal laws that prohibit obstruction of justice. The sixth most general outlaw obstruction of justice proceedings is 18 U.S.C. 1503, witness tampering. 18 U.S.C. 1512, witness retaliation, which he did when he had the investigator fired. 18 U.S.C. 1513, obstruction of congressional or administrative proceedings. 18 U.S.C. 1505, conspiracy to defraud the United States. 18 U.S.C. 371, in contempt, a creature of statute, rule, and common law. The laws that supplement and sometimes mirror the basic six tend to prescribe a particular means of obstruction. Some, like the perjury and false statement statutes, condemn obstruction by lies and deception. Others, like bribery, mail fraud, wire fraud, prohibit obstruction. That doesn't apply here. Still, others ban the destruction of evidence, which we know happened. A few simply punish tipping off those who are at the target of an investigation. Okay, so he didn't tip them off, he just made sure they weren't even interviewed, okay? Many of these offenses may provide the basis for racketeering and money laundering, persecution, which doesn't apply, but each provides the basis for criminal prosecution of anyone who aids and abets or conspires for their commission. Moreover, regardless of the offense for which an individual is convicted, his sentence may be enhanced as a consequence of any obstruction of justice for which he's responsible, if committed during the course of an investigation, a prosecution, or sentencing for the offense of his conviction. Enhancements may result in an increase in term of imprisonment by as much as 4 years. 4 years, guys. I think it's 3. I'm going to go down here. Okay, subordinating perjury in a grand jury proceeding, that's 5 years. Interfering with the investigation is another 5 years. You could put an enhancement of those 4 years each. Let's see, we'll go down here. 2 counts of USC 1621, which outlaws presenting material false statements under oath in a federal official proceeding, is a maximum of 10 years. 1 count of 18 U.S. Code 1622, subordinating perjury, procures another to commit perjury, is guilty of subordinating perjury, and shall be fined under this title or imprisoned not more than 5 years or both. So we're looking at, 15 to 25 years. 18 U.S.C. 1503 is a felony offense for which a sentence can be 10 years imprisonment. A parallel provision concerning the due administration of justice is 18 U.S.C. 1505, which is obstruction of administrative proceedings, a maximum of 25 years total if you add all these counts up. So he could be looking at anywhere between, if they want to put enhancement charges on there, guys, 4 years each, 4 charges times 4, is 16 years. Add that to the maximum 25. So you're looking at what? What did I just say? 30, what is that, 41 years, guys? So for the 4 counts, if criminal charges were levied against him, he could be looking at as much as 40 years, 41 years, something like that, guys. So isn't it kind of odd or ironic that this man, Stephen Myrie, is seeking prosecution of men, wanting to put them in prison for life? Isn't that amazing? So I hope you guys find this as ironic as I did. But the sad part about it is we would have to get a federal investigation going, and we know how that goes when the federal government investigates itself. But this is something for us to think about, how we could get this investigation, because Dan Love was investigated for these very same things, interfering with an investigation, and he got fired for it, among other misbehaving things he did. But, the least we could hope for is the firing of Steve Myrie, and maybe to be disbarred and have his law license taken away. The most we could hope for is criminal prosecution, for him to be on the other end of the stick where he likes to put everybody else. But if none of these things ever happen, maybe the men that were put on trial would, file a civil cause against him. So there are avenues to deal with people like this. I just wonder, after all this time, are any of these men up for another court battle? Because asking the government to do something about the government, it's like pulling teeth. But anyways, I wanted to share that information with you guys, and to take a look at what Steve Myrie could be facing if the guys are found not guilty, or if the judge dismisses these charges with prejudice. He could be looking at a malicious prosecution civil case being filed against him. We could call for an investigation of his behavior surrounding this case, and hopefully criminal charges would be levied against him, because we know if they obtain a conviction, the Ninth Circuit Court is not going to overturn him. And we know that Judge Gloria Navarro here, handpicked by Harry Reid, is going to do what she can to continue this charade, this game. I wonder if she's going to offer the defense candy now to try to make them feel better. All right, guys, I'll talk to you later.